Hi everyone, welcome to Botak Roy's Property Talk. Today I'm going to talk about the option to purchase agreement, in short the OTP, specifically to private residential. So first, let's understand what an OTP is. It is a legal contract between the buyer and the seller of a residential property transaction, and it gives the buyer an exclusive right to buy the property from the seller in the future. Now everything starts with the buyer paying the seller an option money. Typically it's 1% of the property price, and in return the seller will then grant the buyer an OTP. Now with the OTP, the seller cannot sell this property to any other parties within the option period. Now for the buyers, you are not obliged to buy the property from the seller, but within the option period, you can consider whether to buy or not to buy. And if you choose not to proceed with the purchase, then the seller has the right to forfeit your option money. Now let's move on to take a look at an actual OTP itself. What you see in front of you is an actual OTP. There are a total of 2 pages, and I'll be running through with you the clauses in the OTP and highlighting to you what are those critical ones. Now for the sellers, I'm sure you have your agents with you, so he will be helping you prepare this OTP for the buyers. Now the first thing you need to write into the OTP is the purchaser name and the NRIC number. In the OTP, when you see purchaser, it means the buyer. If you see the word vendor, it means the seller. The first thing I need you to pay attention to is the word and or nominee. You can either strike it off or leave it as is. So what does it mean when you strike it off? It means that the names that you indicate here as the purchaser cannot change. And if you leave it as it is over here, then the seller, please beware that you are giving the buyer an option to change the names of the buyer. So for the seller, please take note of this, and for the buyer, if you have such a condition, do bring it up to the seller and establish an agreement. So typically, why do clients want to leave it as is because usually that the buyer has yet to decide which name to put into the property at that point of receiving the option. The next segment is very straightforward, which is the property address. So write down the property address over here, followed by the option money. And this is typically 1%. So work out that 1% of the property price and have it written down over here. And it will be via a check. So write down the check number over here. And buyers do ask the seller which name should the check address to. And typically that person who is receiving that option money, his name will be written here as well. So with this option money paid to the seller will then in return grant the buyer this option to purchase. Now there's an expiry date to this option, and that period of time we call it the option period. Typically with a 1%, the option period is 2 weeks. So with that agreed date, you have to write it down over here. And do take note that the expiry time is 4 p.m. on that agreed date, on the agreed expiry date. Now if the buyer do not exercise by that date at 4 p.m., then this option shall be null and void. And having it not exercised, then the seller will have the right to forfeit the buyer's option money. Now if the date falls on a Saturday, Sunday or public holiday, then the expiry date shall fall on the next working day immediately after the expiry date. Now this 1% option money and 2 weeks option period is for normal situation, but there are cases where the buyer may be asking for a longer option period to maybe about 1 month. Some can ask for like 3 months or even 6 months or more. And typically why they ask for such condition is because they may need to sell their current property, current house, before they can exercise the new purchase to avoid ABSD, additional buyer stamp duty. And because of the extension, the seller may ask for a higher option money. So there are times that you may see the option money may go to 2% or even 3%. So all this needs to be put on the table to be discussed between the buyer and the seller. Now let's talk about the buyer exercising this option. There's a section marked acceptance copy on page number 2 where all the buyers need to sign over there if they choose to exercise this option. Thereafter, to deliver the signed OTP to the seller's law firm. Together with this, the buyers need to send in a check, which we call it the exercise fee or deposit. And for a 1% option money, the exercise fee shall be 4%, and this is for a normal situation. But as mentioned earlier, if there are special conditions to extend the option period, then this amount may be different. So work out that amount and have it written down over here. The next section is a stakeholder clause. It's about defining the stakeholder to hold the exercise fee. And why do we need to do this? Is to protect the buyer in case the seller went bankrupt or the whole transaction cannot complete due to legal reason. So at least having it in a stakeholder account is easy for the buyer to get refund. So this is the main reason why we have this over here, and there is two options for the sellers to choose. One of the option is to have it hold at the Singapore Academy of Law, and the second option is to have it hold at the lawyer's CVY account. Now the difference between these two is that for Singapore Academy of Law, your law firm, the seller's law firm, will need to do additional procedure to retrieve the exercise fee at completion time, and there will be a few more forms, a few more steps to do that. Plus the law firm will charge you a fee for doing that. But for the CVY account, it's very straightforward using their CVY account, so you will not incur additional cost. The next section is about the seller's appointed lawyer's information. So have it written down over here. And this paragraph here states that the option money from the buyer shall be forfeited by the vendor in the event that the buyer choose not to exercise. And once the buyer exercise this option and sign on the acceptance copy, then a binding contract of the sales and purchase of this property is being formed between both parties. Now, please take note, the option money paid by the buyer shall form part of the purchase price that is being agreed between both parties. The next section is about terms and conditions of this OTP. Number 1 talks about the conditions and rules that govern this OTP. This OTP is subjected to the Singapore Law Society's Conditions of Sales 2020. And it cannot contradict two rules. The first is the Conveyancing and Law of Property Conveyancing Rules 2011, and the second one is the Singapore Academy of Law Conveyancing Money Rules 2011. Now, if there's any conflict to the conditions and the rules, let's take a look at what is stated here. Where terms and conditions of these options are in conflict with the conditions, the former shall prevail. Meaning that if this OTP's conditions is in conflict with the Singapore Law Society's Conditions of Sale 2020, the conditions in this OTP shall prevail. Now for the rules, let's take a look. Where the terms and conditions of this OTP are in conflict with the two rules, then both that rules, the conveyancing rules and the Singapore Academy of Law conveyancing money rules shall prevail. So do take note of that. Now next is the agreed sale price. So the agreed sale price will be written down over here. Number 3, the title shall be in good order, properly deduced and free from encumbrances. For encumbrances, your lawyer will be doing the checks for you, but you can always go to Inlist and do a search yourself. It will cost you $11, and typically if you take a bank loan and you use CPF for your property, you'll see these two as encumbrances tagged to that property. So before completion, you need to make sure you pay up the loan and also arrange to return your CPF money that is being used together with accrued interest to CPF. Now number 4 says that the purchaser shall not require the delivery of production of any deeds or documents not in the possession of the vendor. So this is very self-explanatory. Number 5 I feel is very important. So you can either sell it vacant or subject to existing tenancy agreement. So if you are selling with a tenancy at the moment, remember to strike this off and keep this there. And if it's not with a tenancy, then you strike this off. Number 6 is about furniture and fittings. So if the seller agreed to pass down any items down to the buyer, do have them recorded into an inventory list, because completion is quite a few months away and people do forget about things. So we want to avoid going into conflict that there is an agreement that you're going to give this to me and then now it's not there when I take over the unit. So have them documented inside the inventory list. Number 7 states that the property is also sold subject to restrictive and any other covenants and conditions, party wall rights, and other easement and reservations, if any. If not, then it has to be free from encumbrances. Number 8 is very important. It's about completion, and it's being written down here in the form of number of weeks upon exercising the option. Now typically it's 12 weeks typically, and this 12 weeks allows the bank, if the seller takes a bank loan, for processing the early redemption, because the bank, typically most banks needs 3 months to do that, and if you do it earlier than 3 months, there will be an interest in lieu that will be charged to the client. So the reason why the 12 weeks. And also within these 12 weeks, the lawyer will be working with CPF to prepare for the CPF return. Now there are cases where these 12 weeks can be earlier to a period of 8 weeks, and this is possible if the seller do not have any CPF used or outstanding bank loan. Then 8 weeks may be possible. So do check with your lawyer, because they will be able to advise you according to your situation. Now most of the time the completion period is dependent on the buyer, because for them to get their funds ready, especially those who needs to sell their house for the completion of their purchase. So you may see sometimes the completion period may be even longer than 12 weeks. So buyers and sellers, you can have a chat to agree on a comfortable timeline that is acceptable for both parties. Number 9 is very important. It states here that the purchaser shall be deemed to have full notice of the actual state and condition of the property in all respects, and shall not be entitled to raise any objection or requisition whatsoever in respect thereof. This is a as is where is clause. So for the buyer, before you put in an offer or before you make a decision to exercise the option, please make sure that you do your checks and inspection of the property thoroughly, because once you exercise the option, you are deemed to be fully aware of the actual state and condition of the house, and you cannot make any claims after that. So buyers, please take note. Number 10 is about meeting government departments and LTA's regulation, and the buyer's lawyer will be seeking legal requisition and applications for interpretation plans to this department. Now the expectation is that the replies has to be satisfactory, but in the event that it is unsatisfactory, then this agreement may be rescinded at the buyer's option. As such, now the seller will need to refund to the buyer all monies paid by the buyer to the seller or to the seller's law firm, and without any interest, compensation or deductions. Neither party shall then have any claim or demand against the other for costs, damages and compensation or otherwise. Next is 11, and it's about agent fees to be discussed between the seller and the agent. Number 12 is about the seller appointing a law firm to be his legal agent. Number 13 is about an en bloc that took place before completion, and there will be a fresh sales and purchase agreement that needs to be executed between the buyer and the developer. So this entire 13 will take care of that situation. Number 14 is about payment made by way of check. So the check needs to be honored on first presentment. So for the buyers putting in a check, make sure that there is enough fund for the check to go through. 15 is about non-Singapore citizen buying landed property in Singapore. He will need to obtain a written approval from the Land Dealings Approval Unit, in short LDAU, from SLA in order to do that. So for non-Singapore citizens, please take note of this clause. Number 16 and 17, you can have a read on that one. The next segment here is very important. This is the date that the seller grant the buyer the OTP, and all the seller will need to sign over here. And a witness is required, and this witness can be anybody of legal age 21 years and above. And if you have an agent representing you, you can have your agent to be the witness. This next section is also very important. This is where the buyer exercise the option. This shall be the exercise date, and all the buyers will have to sign over here. A witness is required, and anybody of legal age 21 years and above can be the witness. Now the buyer will need to execute this, the exercising of the option, at their lawyer's office. So with this, I've covered the private residential OTP. I hope by today's sharing you have a better understanding of an OTP so that you are better prepared in your next property transaction. Thanks for watching.